All right, we will take up the last oral argument of the morning. It'll be Project Orlando and Jim R. Palmer versus PSP.
Good morning. May it please the court, I'm Barry Rigby. On behalf of appellants, I would like to reserve 5 minutes for rebuttal.
All right, you may proceed.
As the court knows, we're here on an appeal from a summary judgment, and the underlying litigation was handled in the Orange County Complex Business Court Division. After extensive filings, loan agreements, many variations on loan agreements, the court issued a summary final judgment that was fairly detailed and lengthy. And we have raised a few issues on appeal. The first issue I would like to address is our assertion that because of the cross-claim that was filed in a related eminent domain action, which happened for the first time to include an allonge, and we contend a necessary allonge, and then that cross-claim being moved into the primary case but ultimately dismissed, it had the effect of amending the original case.
Is there any case law that holds that?
That it had the effect of amending it?
Yeah.
We would just ask the court, I don't have any case law to answer the question directly, no, but if the court looks at what was asserted, because they are duplicate as to 2 counts, the foreclosure and then the action on the loan, we would respectfully suggest that that is what has transpired there. But if the court can't reach that conclusion just based on a review of the pleadings, what we also see is that allonge is nowhere else except as part of that cross-claim, and it has gone away with their dismissal.
You know, if I'm a trial judge on the mortgage foreclosure case and a cross-claim gets transferred to me from another division and it seems duplicative, you know, I could see a trial judge saying, do we really need this? And if the party said, no, we don't really need it, let's get rid of the cross-claim, would you similarly be arguing that the court had no jurisdiction had lost jurisdiction over the mortgage foreclosure?
We wouldn't be arguing that the court lost jurisdiction because the initial complaint would still be there from that standpoint. This was a voluntary dismissal, and if you read the voluntary dismissal, it did not reserve anything in respect to the initial complaint, and I would anticipate if the trial...
Did it voluntarily dismiss the cross-claim?
It did.
So how would they be able to dismiss the cross-claim and not the original complaint if that wouldn't do the trick?
Well, let me come about that answer in an indirect fashion. A lot of the case law on the effect of a voluntary dismissal and saying it ends jurisdiction stems out of a mistake by an attorney in deciding to take a voluntary dismissal. I'm not saying it was a good practice, but we're suggesting if they wanted to preserve that case, the underlying claims, there should have been an express statement in that voluntary dismissal. It says this doesn't impact, or we're reverting back.
Your argument is the court had no jurisdiction, correct?
Yes. And our assertion is it renders the judgment void and can be attacked at any time.
If there was no jurisdiction, obviously, but...
Right. And again, by dismissing the cross-claim, they dismissed the one thing that referenced the allonge properly. And as you know, part of what we have claimed in here is there was no standing because the documents that were filed initially did not have an endorsed note or an allonge. Documents that were filed later on purported to have the actual original documents, yet there are discrepancies in the documents. There are blanks that were subsequently filled in. And the affidavit of Mr. Pinckney that was part of an extensive filing with a lot of attachments doesn't explain why there are different versions. The note attached to the original.
He had actual knowledge of all this, correct?
Excuse me?
He had actual knowledge. He was the original guy that drafted documents and things, I think, if I recall from the record.
I don't know if he drafted them, but certainly his affidavit recites that he had a lot of personal knowledge. I agree with that.
Okay.
Is your position that the documents that were filed later, including the affidavit, were insufficient to establish standing, or that they were required to match the documents that were filed with the complaint at the inception?
Our position is that because of the discrepancies in the documents, there is a genuine issue of fact that this shouldn't have been a summary judgment case.
So discrepancies aside, let's say there was no discrepancies, would the evidence submitted, including the affidavit, be sufficient to establish standing? Was there any deficiencies just in that group of evidence?
The standing had to be established at the time of filing the complaint, and Mr. Pinckney alleged that I had the original note and launch at the time of the complaint was filed. That probably meets the threshold in the absence of the discrepancies. We also, in the case law, has got various fact patterns that cited in the briefs. You all have to also look at the issue of to what extent there were affirmative defenses raised as to standing, and was that affidavit enough to clear that burden? It's our position that the affidavit was okay, but not for a summary judgment, that this is the type of thing based on the pleadings, the affirmative defenses, and then, of course, the discrepancies, that it should have been a trial. And we would also respectfully suggest that's what the trial court did. If you read the judgment,
Before you get to the affirmative defenses,
Sir.
On standing, they could get there both with the allonge or alternatively with the assignment, correct?
There is case law that says that standing can come from the assignment. It appears that that's what happened, but
Are there any issues here with their evidence on the assignment? I mean, didn't your client, in fact, confirm that there had been an assignment?
there were restatements, revisions to the documents over time. That is correct. The timing is a curious thing that we believe.
Okay, but leaving aside the allonge and any inconsistencies, is there any issue that would preclude the trial judge from entering summary judgment or finding standing based on the assignment and the summary judgment evidence it received on the assignment?
I'm going to answer that in this way, and I'm not trying to be evasive. An assignment alone doesn't necessarily carry with it an endorsed note or an allonge. Theoretically, a person can assign something, retain the original note, and reassign it to multiple people, and that's why we have the original.
Right, but if the summary judgment evidence was that this company assigned the mortgage and note to this company prior to the second company filing summary judgment, or filing their complaint, would that establish standing?
If they possessed the original note or endorsed note or allonge at the time the complaint was filed, that would.
Okay.
So it's your position that because the note filed with the original complaint had discrepancies from the later filed note, that creates an issue of fact as to whether the assignment was actually proper?
Yes, and I believe there were some blanks in some of the documents, and the timing in and of itself is curious why there was even a cross-claim asserted in the first place. We would suggest that that is evidence on its face that PSP understood that they may have an issue that they needed to cure with a new filing.
And am I correct that you primarily base that argument on Ortiz? Is that the case that you rely on?
I don't remember that particular case, the Ortiz case.
Okay. Speaking about the presumption that if the note filed with the original complaint is in substantially same condition as the later filed note, that there's a presumption that standing was possessed.
Yes.
So my question is, isn't that case limited to application of a presumption, rather than a legal sufficiency of the evidence?
I believe your interpretation of that case is correct, but we would say that these were not in substantially the same condition. Thus the question of fact. Time check.
I think you've been going into the affirmative defenses.
Affirmative defenses.
Well, all that I would say about the affirmative defenses is they raised the very first affirmative defense, both on behalf of the individual defendant and the corporate borrower, raised standing. Standing was raised. They filed these voluminous filings, the affidavit with all the attachments, 4 years later saying, oh, by the way, we had this allonge prior to the time you filed the complaint. But they didn't ever explain why it took so long and where was it back then. That is the kind of question of fact that we submit. A judge has to hear the witness and determine the credibility of the witness. And of course, somebody in our position is going to be in a disadvantage in preparing an opposing affidavit. All those documents take place, those type of things take place on the turf of the lender. We wouldn't be in a position to say, no, that's not really what happened, because we're not there. So then you have to get into the situation of taking live testimony and let the judge act as a trier of fact and assess the credibility of the witnesses. We believe the timing of that it wasn't there when that original complaint was filed, and then another complaint being filed in a different case, those raise questions of credibility and authenticity that warrant this matter not going to summary judgment. And again, would say that judgment on its face reads like a trial judgment. The trial court struggled with a lot of information, we know that, but they made a lot of determinations that really were assessments of the authenticity of documents. They made determinations that we contend were questions of fact. Just give you a couple examples. We say it's a question of fact as to whether the allonge was in existence at the time of the complaint, whether the loan documents were authentic, what was the amount that was claimed as owed due, and there was an expert report on the usury issue that was submitted in response to the motion for summary judgment, whether documents were altered. So we say there are a number of things that the trial court considered, made a finding on, and to some degree added in that there was no genuine issue of material fact, rather than what we would like in a perfectly clean summary judgment order that says there's no genuine issue of fact here, so as a result, here's what I'm going to do. We would suggest that the reading of the final judgment is evidence right there that the trial court was resolving questions of fact. All right, no other questions. I'll sit and let counsel.
All right, thank you.
May it please the court. My name is Greg Brown, and I represent PSP MRC Debt Portfolio S1LP, which is a mouthful, and it's a Canadian public pension fund, and we referred to it throughout the case below as the fund, and that's how I'll refer to it here. There are three arguments made by Project Orlando. I think there are some additional facts. It sounds like the court is well familiar with the record, but to add some facts, this is a loan that was made in December of 2006. The fund lent Project Orlando $46 million. The loan had a one-year term. When the loan could not be repaid in that one-year term, it was modified 5 times and then modified again 2 additional times with forbearance agreements, taking the maturity date of the loan out to March 31 of 2011. In those various loan and mortgage modifications, as the court points out, Project Orlando ratified the debt, the amount of the debt, in various documents, and also acknowledged that the owner and holder of the debt was the fund. In fact, in the fifth mortgage modification agreement, Mr. Palmer, the principal of Project Orlando, who at the time was a member of the Florida Bar, provided an opinion letter through his firm acknowledging the fund as the lender. There was also an estoppel certificate that Project Orlando signed in connection with the assignment of the loan from MMA to the fund, which occurred in April of 2007.
Doesn't have anything really to do with, where is the property located?
The property, Your Honor, is located,
It's like 830 acres or something?
yes, 863 acres, I believe, that is in Apopka, sort of on the northwest end. This was sort of the completion of Beltway property around the Wekiva.
There was a condemnation for that Greenway or whatever, too. wasn't it?
That's correct. And frankly, this is sort of, we believe, a loan made in anticipation of an eminent domain for property, for the completion of the Wekiva Parkway that would run through property.
I kind of know what you're talking about now. Okay.
And so, Your Honors, after the foreclosure claim was brought, we would submit that Project Orlando, for years, successfully evaded service of process. The reason I bring that up, because that issue was brought up on interlocutory appeal, and it was determined by this court, presumably, it was PCA'd, that service was successfully accomplished in the case, and the appeal was returned. The reason I bring that up is to explain why it was that we went to the eminent domain court to, in effect, grab the jurisdiction of the court and then carry it back to the foreclosure case. And that's why we did what we did in amending admittedly very similar cross-claims in the eminent domain case. The case was then transferred, or those claims were transferred back to the foreclosure court. In the interim, Judge Blackwell entered an order finding that we had successfully obtained service of process in the original counts, and therefore, rather than somehow amend.
Purpose of the cross-claim originally was the service issue, correct?
That's exactly right. We had Project Orlando affirmatively prosecuting a claim in the same court where it was evading service of process in the foreclosure case, so that was our effort to try to overcome that. So we brought those cross-claims over. When the court found that we had successfully obtained service of process, finally, over Project Orlando, we dismissed those cross-claims, and I should point out, with specific reference to them. It wasn't, I would invite the court to look at the record, pages 165 and 166, and look at the notice of voluntary dismissal. We believe the court will find that we expressly dismiss just those cross-claims. So the first argument, Your Honors, relates to and presumably the principal argument made by Project Orlando was somehow that because of perhaps a mistake that occurred or some legal principle of merger concerning the claims, that we unintentionally, and the fund unintentionally, dismissed its $80 million foreclosure case. We don't believe that claim has merit. To follow up on your point, Your Honor, there's been no case law cited for the support that somehow by operation of law similar claims merged together. Clearly, to amend a complaint, there are processes identified in the Florida Rules of Civil Procedure, and we didn't undertake to somehow try to merge those claims together. It's hard to imagine the principles supported by such a legal edict. Maybe the law of unintended consequences, but we do believe And we think the record indicates that we very clearly, simply dismissed those cross claims, and it had no effect on the remaining pending claims. With respect to the second issue, the standing issue, we believe that that argument also lacks merit, and candidly, we think it sort of relies on a bit of wordplay. If I follow the arguments made in the brief, it appears that the argument is that you have to successfully establish or prove standing at the outset of the case.
And I think I understand the argument that, the argument to be that the difference between the documents filed at the beginning of the case and the documents filed for summary judgment were so different in their argument that creates an issue of fact as to whether the evidence, was sufficient. So what would be your argument to that factual discrepancy?
Well, Your Honor, first I would point out that if you were to look at, and you mentioned the Ortiz presumption, and we don't brief that specifically in our briefs, but we do cite to the Ortiz case, and I will concede we cannot rely on the Ortiz presumption in this case because there was no allonge attached to the note, and the original note differs from the copy of the note attached to the complaint differs from the original note and mortgage that we deposited with the clerk of courts at the summary judgment stage. So, Your Honor, this particular issue is sort of well meted out at the appellate level, including by this court, and we would cite to the Glenn Guerin v. Buchwald case, which appears at 210 Southern 3rd, 229, where that precise, in that case, the facts were that there was no note attached to the complaint. Let me back up a moment to directly answer your question.
And I guess, let me rephrase the question. Was there evidence that submitted at summary judgment to explain the discrepancies? In other words, that there had been, multiple copies signed independently instead of just a photocopy made of the original documents?
Your Honor, no, that wasn't an issue that was discussed in our in the evidence that we submitted, and there was no countervailing evidence. There were no affidavits submitted. The issue wasn't briefed or addressed at summary judgment. And what I was going to say earlier is if you were to compare those two documents, if you look at the signature pages and the notary block, that they appear to be the same document. The one discrepancy is that there are dates filled in the blanks in the original note and mortgage that was ultimately deposited with the clerk in the court registry. And so, returning to the Glenn Guerin case, that was precisely, that was the form of the argument taken there that actually was accepted at the trial court level on a motion for judgment on the pleadings. The trial court said you can't fix the fact that you failed to attach a note, and there's an additional case, the Jaffers case out of the 3rd DCA, where there was an actual discrepancy between the note and attached to the complaint and the note that was filed in the court registry. The ultimate holding of this court, and we believe the fourth, is that issue is overcome by depositing the original note along with an allonge in the court registry, which is exactly what we did. So we would say what we think you're hearing is that creates some disputed question of fact. The law would suggest it's not a material disputed question of fact, and the real issue here is standing, and not whether or not we establish standing at the beginning of the case, but whether or not the fund had standing at the beginning of the case. And clearly it did. Again, there were a number of documents that were executed by Project Orlando acknowledging the transfer. We proved with the facts submitted at the motion for summary judgment stage that the note had been assigned to us, and then ultimately deposited the note along with the original note and the original longe with the court at foreclosure, which the Glenn Guerin case says, overcomes any defect. So finally, with respect to the third argument that was raised by Project Orlando, that somehow the pleadings were insufficient to overcome the affirmative defenses that had been pled, we understand that the focus of that argument is on the usury defense. We would point out that the only reason that we would have to file a reply would be if we were relying on new facts in avoidance of the affirmative defenses, and we were not relying on any new facts. The waiver argument regarding usury arose out of documents that were attached to the original complaint, had not been stricken. That was one of the bases upon which the court found that there was an inadequate usury defense. But perhaps more importantly, what Judge O'Kane did was apply the undisputed facts to the law, most notably the spreading statute and the Ham decision, which is a Florida Supreme Court case that sort of articulates how you do the math under the spreading statute. And Judge O'Kane ran through the mathematics effectively, determining that there was no usurious interest charged. So we believe that the court properly applied the undisputed facts to the law and ultimately determined that there was no usury. So,
Any other questions? All right, thank you.
thank you.
Again, may it please the court, thank you for your gracious patience this morning. I'd like to commend counsel. I think he's been very honest and straightforward in his recitation of the facts, and something I note and appreciate. He's highly professional in what he does. Just to touch on a couple of the cases he cited, we would say the Jaffer case is distinguishable because in the Jaffer case, the defendants didn't file affirmative defenses. And that was their downfall in that case. They had not created the facts that were necessary by failing to do that. And the court said they had waived certain defenses by failing to do so. In the Glenn Guerin case, it dealt with a motion for judgment on the pleadings, but in that case, there was a note and a longe attached at the time the case was filed. We don't have that here, and I know that there's curiosity, and Mr. Brown explained to the court about the cross-claim. We have different versions of what took place in the service process, but be that as it may, what we know from a review of the record is that the cross-claim addressed the allonge for the first time, and no effort was ever made to go back in the original underlying case, seek leave to amend, tender an original note and allonge to amend pleadings, anything. It was only in that case that was dismissed, and we believe that defect, the timing again, the timing issues, and the discrepancies warrant an evidentiary hearing. There's a case out of the 4th District, the McLean case, that touches on some of these things, and it just got some nice language in it that it says, it's 79 Southern 3rd 170, an evidentiary hearing would have been the appropriate forum to resolve the conflict which was apparent on the face of the assignment. And it goes on to talk a little more. We're submitting this was an evidentiary hearing case, and it's sort of what the trial court did, is conduct a mini trial on it. Lastly, counsel pointed out the size of the loan. Some of it was paid back. We would respectfully suggest that with the amount at issue here, perhaps it should get a higher level of scrutiny. I know there's some different standards when you're dealing with residential or commercial, and it's somewhat disputed here whether this was commercial or residential. It's my understanding there's some residential properties on the land. But the amount of the loan at question, we would respectfully say, should be reason for the court to hold the lender to the highest of standards as they pursue and try to get their judgment and collect on it. We believe that some of the issues here are interesting, and the questions are good. What does the assignment do enough? Things like that. It's certainly an opinion-worthy case. So we're respectfully requesting that it be reversed, the summary judgment be reversed, the case dismissed, and let the plaintiff, the lender, go through and file a new case. Thank you.
All right, thank you both,
Thank you very much.
and the court will be in recess.